afternoon. My name is Kim Stanger, and we are here for our next webinar, talking today about provider contracts, tips from the trenches. Hopefully you've all received a copy of the written materials. If not, you should have received a link that has those written materials available. If you did not receive that link for some reason, then go ahead and send Laura an email. I sent her contact information in the chat feature. My purpose today is basically to avoid this situation when you're traveling down the road thinking that your physician contracts are okay and suddenly something happens. I'm going to give you essentially the things that I've gathered over my past 20 years in dealing with physicians and physician contracts to identify some of the key points and issues that may come up in common contract terms that you may want to consider, and perhaps go back and evaluate your own contracts to see if they should be improved. We're going to talk briefly about the relevant statutes that apply to physician contracts or provider contracts, could be mid-levels, and then we're going to apply some those statutes as well as common contract terms to different types of agreements. As far as preliminaries, the written materials we provided to you include our PowerPoint slides. I've given you copies of the relevant Stark and AntiKickback safe harbors that you can compare those against your current contracts. I've given you also some commentary from the Stark rules that gives you a helpful chart identifying the types of contractual relationships and the different requirements for each one of those contractual relationships. I've given you a couple of client alerts that I've done. This presentation, like all of our presentations, is being recorded and will be available in the future on our Health Law blog website, should you have any questions or want to go back and review it. As we go through today, you may have questions. You can submit those using the chat feature or just shoot me an email, and I'll respond offline to those things. Also, by way of preliminaries, I'm going to be talking about some of my preferences when it comes to contracts, but, you know, everybody likes their own forms, I suppose. So just remember, when it comes to the contract, one size does not fit all, and ultimately you need to make sure that you tailor your agreement to the particular circumstances and needs of your situation. You also need to make sure that you check state laws and regulations to ensure that the contract terms comply with your particular state. Make sure that when you're drafting contracts that you remember your goal is to avoid misunderstanding down the road. I can't tell you how many times I get a contract that was initially drafted by the client comes in there and I read it, and quite frankly I have no idea what the client meant. Or I think I have a pretty good idea, but remember the question is not whether the client knew what he meant, it's whether the other parties knew what he meant. Whether the other party or the court or in some cases regulatory agencies. So it's not enough to draft the contract just so it reflects what you intend. You need to draft the contract in a way that the other parties will understand and there can be no misunderstanding. Because if this ever does go to court, then the court is going to open it up and try to determine the contract based on what's in there, not necessarily based on what you intended, but what appears actually in the contract terms. Also, having that clear contract set out can avoid misunderstandings with the practitioner themselves, the provider. You don't want a situation where they have a dispute about what it does or doesn't mean. That could create bad feelings and kind of and submarine the whole relationship. It's better if you can resolve those misunderstandings up front. Just fair warning, my comments today generally favor the employer. I represent a lot of hospitals, a lot of physician groups, so I'm usually drafting and looking at these things on behalf of the employer side. For you who are individual physicians who may be looking at this, then just remember, in a lot of situations you may take the opposite view, but hopefully this will point out the key issues. Remember also that the terms are going to vary between whether it's an employment contract or an independent contractor relationship, which brings us to the first issue. You've got to decide whether or not you're going to structure this contractual relationship as an employment or an independent contractor relationship. There are consequences that follow that. If it's an employment agreement, then generally the big test is whether the employer has the right to control the means and the method of how that particular employee conducts the work, performs the work. Right of control is the ultimate test. If it's an employment situation, that employer has to withhold taxes. In addition, the employer is going to be vicariously liable for whatever that employee does, as long as the employee is acting within the course and scope of the agreement, and the employment laws are going to apply, things like the discrimination statute, wage and hour laws, things like that. On the other hand, if it's an independent contractor, theoretically, you don't have the right to control an independent contractor. The employer does not pay or withhold taxes on behalf of the contractor. Instead, the employer is going to issue a 1099. But, of course, if it smells like or walks like a duck, quacks like a duck, the IRS can come in there and determine, no, it really is an employment situation, and if that employee has not paid the appropriate taxes, then they can go after the employer to recover those taxes that weren't paid. If it's an independent contractor situation, generally the employer is not vicariously liable because if they don't have the right to control what the employee does, then the employer shouldn't be liable for that. However, you have to be aware of actual or apparent agency. In those situations, even though there wasn't actual agency created where the contractor may have, the employer may have specifically delegated duties to the contractor, if the employer did something to hold that agent, that contractor out as if they were their employee, then that employer can still be vicariously liable. In determining whether or not they are an employer or an employee, at least for purposes of tax, you need to be familiar with the IRS 20-factor test. You guys probably are all familiar with that. The government has recently updated that. You can go to the government's website, the IRS website that's up there on your screen, and they go through and they talk about the different factors that weigh into determining whether or not this person is really an independent contractor or whether they are an employee. Now, I will tell you this. When I've looked at most of the independent contractor arrangements, the professional services agreements, even though they're set up as independent contractors, if they're done with individual physicians, quite frankly, a lot of them smell like employment contracts. And so you have to be a little bit careful about those situations and make sure you walk through that analysis and determine that you've properly classified that person. We'll talk about some of the factors as we go through. You need to make sure that your contracts comply with applicable laws. Certainly the general employment laws that apply, like discrimination, wage and hour laws, things like that. I'm not going to talk about those today. I'm going to be talking a little bit more about the healthcare specific laws, particularly the Anti-Kickback Statute, Stark, the Civil Monetary Penalties Law, and things like that, because those are the ones that your HR people may not be that familiar with. The first is the Anti-Kickback Statute. It's a federal statute, which says you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by federal health care programs unless you've structured the deal to fit within a regulatory safe harbor. If you violate that, that's a felony. It's also an automatic violation of the False Claims Act, so you can get hit up with civil monetary penalties in addition to going to jail for that. The bottom line is you have to be careful about those situations. Now, employment or independent contractor arrangements can implicate the Anti-Kickback Statute if you are paying for referrals. The key there is to make sure that you structure the deal to fit within one of the regulatory safe harbors. There's a regulatory safe harbor under the Anti-Kickback Statute that applies to bona fide employees. In fact, it's incredibly broad. The bottom line is if you're employing somebody, you usually don't have to worry about the Anti-Kickback Statute. You just have to have a bona fide employment relationship for which you're paying for services that are payable under Medicare and Medicaid and the like. It doesn't have to be written. They don't even specifically talk about it being fair market value. You've got a lot of leeway. However, just make sure that you're aware of this. There has been some unfortunate commentary from the OIG in which they've suggested that, hey, if you are paying directly for referrals in an inappropriate manner, then in that situation it may not fit within the safe harbor because the safe harbor applies to payment to the employee for the furnishing of items or services payable by Medicare and Medicaid, the federal health care program. If what you are paying for is not the services, but you're paying for the referrals for those services, then you may not fit within the safe harbor. I'm not aware of any cases in which the OIG has actually taken that to enforcement, but just beware that it's out there. In addition to the Anti-Kickback Statute, if you want to structure your deal as an independent contractor relationship, a personal services relationship, either with an individual or a group or another entity, then you want to satisfy, to the extent you can, the personal services and management safe harbor. That requires that the agreement has to be in writing and signed by the parties. It has to specify the services to be provided. If those services are provided on a periodic or sporadic part-time basis, you've got to specify the term and the exact length of time for those services. The term of the agreement can't be for less than 1 year, and the aggregate compensation is set in advance. That's usually the kicker when it comes to PSAs or employment agreements, because the aggregate compensation has to be set in advance to satisfy the anti-kickback safe harbor. That means if you've got any kind of a productivity component built in or a situation where the aggregate compensation is not set in advance, then you won't fit within the anti-kickback safe harbor. That doesn't necessarily mean you violated the anti-kickback statute. If you don't fit within the safe harbor, then the test is one purpose of this payment to induce referrals. If that's the case, then you may potentially violate it. So you want to make sure that you structure your deal to fit within the safe harbor to the extent you can. In addition, the compensation has to be consistent with fair market. It can't take into account the volume or value of referrals or other business generated between the parties. And the aggregate services cannot exceed those that are reasonably necessary to accomplish the commercially reasonable business purpose for the service. You have to have a legit reason for this arrangement, not just simply to do it as a way to funnel the money to the provider in order to generate their referrals. That is the anti-kickback statute. Usually not much of a problem when it comes to employment agreements or independent contractor agreements. You're usually more worried about STARK, the Ethics and Patient Referrals Act. STARK applies to contracts with physicians, not mid-levels, but contracts with physicians. STARK says that if a physician or a member of the physician's family has a financial relationship, including a contract to provide services with an entity, that physician can't make referrals to that entity and for certain designated health services payable by Medicare or Medicaid. If they do, that entity can't bill for those services unless you've structured the deal to fit within a regulatory safe harbor. If you violate that, then you can't get paid for the services that were provided per that improper referral, and if you were paid, you got to repay. It can result in additional fines and penalties. The key there is when you've got any kind of a contract with a referring physician, you need to make sure that you've structured it to fit within the STARK safe harbors. Well, what are those safe harbors versus the employment safe harbor? Again, just like the anti-kickback statute, relatively easy to satisfy for purposes of STARK. If it's a bona fide employee, then really easy to satisfy. Generally, it has to be a bona fide employment relationship for identifiable services. The remuneration under the employment is consistent with fair market value and is not determined in a manner that takes into account directly or indirectly the volume or value of any referrals by the referring physician. And that's any referrals for items or services covered by Medicare or Medicaid, not necessarily referrals of non-covered services. We'll talk about that in a minute. The arrangement has to be commercially reasonable, even if no referrals were made to the employer. And you may pay a productivity bonus based on the services that are performed personally by the physician, but not necessarily ancillaries. Pretty easy to satisfy that. You don't even have to have a written agreement, and the compensation doesn't have to be set in advance. It can change if it's an employment situation. On the other hand, if you've got an independent contractor situation, it's a little bit more difficult to satisfy those requirements. There are actually two safe harbors that potentially apply to independent contractor arrangements under the STARK law. There is the personal services safe harbor. There's also the separate fair market value safe harbor, which is usually easier to satisfy. The gist of both of these are as follows. Generally, the arrangement has to be in writing. So if it's an independent contractor arrangement, you have to have a written arrangement. Now, based on recent clarifications that the government has said, that doesn't necessarily mean you have a formal contract, but you would have to have communications, contemporaneous communications that set forth the terms and that are signed by the parties. Hopefully you just have a contract. That makes it easier. That contract has to cover the identifiable items or services. The writing has to specify the time frame for the arrangement, the term. Could be 1 year, could be 6 months. It can be, you may terminate the agreement early, but you cannot enter another arrangement for the same or similar services during the course of a year. So if you've got an independent contractor arrangement, you have to assume that that contract or the terms of the contract are going to remain in place during that 1 year period, and you can't change them within that 1 year period. You can terminate, but then you can't enter into a new agreement within that 1 year period. You can't change the compensation terms for a year. The reason behind that is the government didn't want to have a series of short-term contracts where the compensation changes based on referral patterns. Based on the new Stark rules, you may renew or have holdovers so long as the terms do not change. So you could have a 6-month, a 1-year agreement, you forgot to renew it, but the parties continue to perform consistent with the terms of the original agreement. That's fine under the recent changes to Stark. That's a good thing. The compensation must be set in advance. Now, that's not necessarily the aggregate compensation, but the formula for compensation has to be objectively verifiable and set in advance, consistent with fair market value, and not determined in a manner that takes into account the volume or value of referrals or other business. Under the employment agreement, you only have to, you can't make it vary with the volume or value of referrals for designated health services payable to Medicare. For independent contractors, you can't make it vary based on those designated health services that are payable to Medicare or Medicaid or any other business, so even private pay business. You can't have the contract vary for purposes of an independent contractor arrangement. The arrangement has to be commercially reasonable and further legitimate business purposes of the parties, even regardless of the referrals, and it can't violate the Anti-Kickback Statute. There are also exceptions under Stark that apply to group practice arrangements. So if you qualify as a group practice and fit the definition of a group practice under Stark, then you have a little bit more leeway in how you structure your contracts, particularly with regard to sharing overall profits or productivity bonuses. Briefly, the civil monetary penalties law is also out there. Basically, there's 2 different provisions. The first is, under the civil monetary penalties law, you can't contract with an excluded entity. We'll talk about that more later. Second, a hospital or critical access hospital, if you're a hospital or CAH, you cannot knowingly make a payment to a physician as an inducement to reduce or limit medically necessary services provided by Medicare or Medicaid. Those are gain-sharing arrangements, shared savings programs. Those become problematic under the civil monetary penalties law. The good news is this was recently amended last year so that it only applies to an inducement to reduce medically necessary services. So this has opened up the door so that if you wanted to get into these types of gain-sharing arrangements with your physicians, if you're a hospital or a critical access hospital, then this change makes it easier to do that, although you still have to be careful about doing that. If you're a 501c3, you also have to be worried about the private immurement. Basically, you pay your physicians, your providers, fair market value for the services that they provide. If you pay them more than fair market value, it may jeopardize your tax-exempt status or may result in intermediate sanctions. That doesn't apply very often or come up very often. All right, that gives you a little bit of background about kind of the healthcare-specific issues dealing with contracts. Let's get in and talk about some of the common contract terms. Most of your contracts will always start out with the recitals. Those are the whereases, those things like that. That's just throat clearing. They're not essential. You don't have to have them in there, but it's common to put them in there. I don't like using the whereas language. I think that's just antiquated, and I don't even like using the word recitals. I usually use background. Those can be helpful in that it may set the context for the agreement, establish the purpose, may help you confirm community need, which is important in satisfying the Anti-Kickback Statute and Stark under some circumstances. It may overall provide you with a chance to show why the contract's reasonable, if it's ever going to be second-guessed, and maybe sometimes you include definitions in those recitals or a separate section. At the first, I like to include and specify the nature of the relationship. Is this an employment contract or is it an independent contractor? If it's an employment, is it full-time, part-time, or on an as-needed basis? If it's an independent contractor, make it incredibly clear in the agreement. You want to make sure that it specifically says that the contractor is not an employee, partner, or agent. The contractor does not have authority to subject the employer to liability. That may help minimize your exposure to third parties, although it certainly won't rule it out. Make sure that the employer is not liable for the contractor's acts or omissions. The employer is going to issue a 1099 and the contractor is going to be liable for taxes. You may want to have an indemnification provision that requires the provider to indemnify you if the government comes back, determines this really was an employment relationship and therefore employer, you owe a bunch of taxes. You may want to have an indemnification provision so the provider has to indemnify you for that. Make sure that it confirms the contractor is not entitled to employee benefits, because the provision of employee benefits is an important factor in determining whether they're an employee or an independent contractor. You may want to affirm that the contractor has their obligation to carry their own insurance, including workers' comp, to the extent required by law. That's important for a couple of reasons. One, you want to make sure that that employer or that provider has liability insurance in case they ever do anything wrong and they're sued. Second, the provision of insurance is one of the factors in determining whether they're an employer or an employee or an independent contractor. Third, when it comes to workers' comp, even for independent contractors, some states will require or hold out that that employer is a statutory employer for purposes of workers' comp, and so even though they're working with independent contractors, they may be considered a statutory employer that must purchase the workers' comp for that contractor. So you may want to make sure that that contractor purchases their own workers' comp coverage to the extent required by applicable law. You should pay attention to the effective date or commencement date. Those aren't necessarily the same. Sometimes they're synonymous, but it may be that you're entering into that contract, you know, a year or two or a few months before that physician or provider is actually supposed to show up. In that regard, you may want the contract to become effective on the date the parties sign it, meaning that it's binding on the parties, but the services actually don't commence until sometime later, so you may have a separate commencement date. If you're contracting in advance, you may not know the precise date the provider is going to begin providing services. You may say effective, or they're going to begin by July 1st, but they don't get their credentialing done, and so it's really later. So I will usually have an outside date that they've got to start by no later than such and such a date, but the commencement date is actually the date that they really do begin providing services, so it may be a bit earlier than that. And then you usually run the term and termination provisions off of that commencement date. And one of the key issues is to identify the services that that provider is going to perform. A key here is to make sure that you're not overly prescriptive in those things, that you describe the services in general terms so it covers everything that you want them to do and provides you with some flexibility to add services or to define services as necessary. I'll usually throw in something for providers like that they will perform the services commonly performed by a provider practicing in the specialty of whatever it is, family medicine, orthopedics, whatever, including but not limited to, and then specify some of the common services. Again, avoid being too specific, because if you're too specific, the physician may come back in and say, well, that was never part of my obligations, and therefore you can't take adverse action against me because I declined or refused to do that. You should reserve the right to assign additional duties. Again, at the end, I always put in something like, and such other duties as reasonably assigned by the employer. Sometimes contracts will contain a separate section, a separate attachment where you set forth those duties, and that makes it easier to amend it, or maybe you set forth a job description, something like that. That's certainly fine. Just make sure that the agreement works together. I usually like to include a term talking about the schedule so the physician or practitioner knows generally what their scheduling requirements are, particularly if it's going to be full-time, part-time, or on an as-needed basis. I like to put in the approximate numbers of hours per week. Is it 40 hours a week? Is it 30 hours of clinical time plus additional administrative time on after that? Is it based on patient encounters, or does it also include the administrative time? If it's going to be on an as-needed basis, you want to clarify that there's nothing in the agreement that requires you to provide a minimum number of hours to that particular provider. Instead, it is truly as needed, as determined by the employer. If you describe the schedule, again, do so in general terms. You know, approximately X numbers of hours. If you're going to include weekends, nights, etc., if there's a possibility at all for that, then I would go ahead and include that in there. Make sure you don't forget about call coverage obligations, particularly when you're talking about setting the hourly requirement. Usually I will put in something like, you know, 35 hours a week or 40 hours a week, whatever it is, excluding call coverage. So it's clear that the call coverage is in addition to that. You'll want to reserve your right to modify the schedule as appropriate. So I usually have something in there that they'll provide the services according to a reasonable schedule established by the employer. A lot of times the physician wants to sign off on that I generally don't like to give them veto power if I can avoid it, so I make sure that the schedule is set according to or based on what the employer wants. Call coverage, just a word about that. Don't forget about the call coverage obligations. That is a huge issue, particularly nowadays when a lot of the physicians who are coming out, the younger physicians, they don't necessarily want to participate in calls. So you want to make sure that you clarify the call coverage obligations. But again, reserve the right to modify as you go along. Sometimes if the physician is concerned about having a disproportionate share of call, you may want to put in there that you will that they'll share call on an equitable basis if that's appropriate. You want to specify the conditions on call, particularly that when they are on call, that they've got an obligation to be continually available by phone. And if they are contacted, put in the response time, particularly that they need to respond immediately when they're called by phone call. If they're required to come into the facility or asked to come into the facility, they've got to respond within a certain period of time at the facility. The EMTALA interpretive guidelines strongly encourage facilities to put in, a specific set of minutes, like 30 minutes. I'll usually put in 30 minutes or such shorter time as provided in hospital bylaws or policies. Confirm the obligation to respond if they're called and requested to come in, even if they don't think they need to. If the ED physician or other person thinks they need to, then they need to go ahead and respond. That's a requirement under EMTALA. Make sure that they provide adequate notice if they're unavailable to participate in call and sufficient time so that you can adjust the call schedule appropriately. You may want to impose on them the obligation if they are not going to be able to participate in call to come up with their appropriate replacement, but make sure that they contact the hospital to let them know of who that obligation is and make sure that it has to be a person who's been approved to provide call coverage for the hospital. If you're paying for excess call, that can create some additional issues about who you pay under those circumstances. You may need to address that in your agreement. You may want to have a general provision in there that even when they're not on call, you may want to confirm that the physician will take reasonable or be available for reasonable consults, particularly if they're like a hospitalist or other person that they've admitted somebody, you want them to be available to respond to issues if they come up along the way. You may want to address supervision of mid-levels. If you're a physician and that physician's employment obligations are going to include supervision of mid-levels or other non-physician practitioners, you want to include that in the description of services. If you're going to pay them for that additional services, you want to make sure you address that in the compensation section. If the contract is with mid-levels, then make sure that you include certain terms, particularly that the mid-level is going to comply within the scope of practice rules in your state, that they're going to comply with the delegation of services agreement or the equivalent from your particular state that sets forth what they can and can't do, particularly with physician assistants, that they're going to cooperate with the supervising physician. You may actually want to condition the contract on the availability of the supervising physician. So if you've hired a PA but suddenly you don't have a physician willing to act as supervising physician, then you can terminate the agreement under those circumstances. I like to put in a location of services to the agreement just to confirm that there's no misunderstanding where that practitioner is going to primarily provide their services, the hospital, the clinic, both, whatever, but make sure again that it's not exclusive, that you maintain the flexibility to assign other locations as determined by the employer. All right, this is an incredibly important one and one that is often overlooked in contracts. Make sure that you include appropriate performance standards, because if you have performance problems with a physician, you want to be able to go back and say, no, contract required you to comply with these performance standards. The most important of those is make sure that the physician or provider has to comply with appropriate standards, applicable legal and policy standards. So you want to make sure that they comply with applicable laws and regulations, the community standard of care, licensure rules and scope of practice laws, ethical standards relevant to their particular licensure, accreditation standards, whether it's Joint Commission or others, payer requirements. That's often overlooked. Make sure that your providers are obligated to and they agree to comply with payer requirements that are imposed on them, including CMS requirements and the like. Make sure that they are complying with any employment contracts or employer contracts you might have with third parties. So for example, it may be that you as a group or you as a hospital contract to provide services to a third party. Make sure that if you're contracting with this particular physician to participate in those contracts, that this physician also agrees to comply with the contract between the facility and that third party. Make sure that they comply with the employer bylaws, rules, and policies, including medical staff policies and charity care policies. In addition, you should include in your performance standards that they're going to act in the best efforts, use their best efforts for the benefit of the employer. They're going to act in a professional, cooperative, non-disruptive manner. Again, this is very important. You get that jerk on the staff and you want to terminate their contract, but it's hard to find a provision in there. You want to make sure that you specified that they've got an obligation to perform in a professional, non-disruptive manner, that they respond to patients, providers, or others in a timely and appropriate manner, that they support your quality assurance compliance and other programs, including participating on committees or accepting assignments, that they promote the relevant service line to the public and others so you can call on them to help go out and do community outreach and the like. It's consistent with effective care, that they're going to provide services in an efficient, cost-effective manner so you don't go out of business. Immediately notify the hospital of circumstances giving rise to potential claims, whether they're sued or an investigation's brought, that you get the notice immediately so that you can respond appropriately. And use the catch-all that they will adhere to such other performance standards as reasonably established by the employer. Bottom line here, if there are certain things that you expect your physicians or other providers to do, reference it in the contract so that if they decline to do that, it forms the basis for an action against them and allows you to terminate the agreement. One of the chief issues there, either in your performance standards or a separate provision, is make sure you require your providers to timely complete medical records. Huge issue out there, very important for you as the employer. Now, sometimes employers want to put in place penalties if they fail to timely complete the records, either some kind of a monetary penalty that they have to pay $500 per day for records that aren't done, or that they want to withhold the compensation until they pay. If you've got an employee, those types of penalties are probably going to violate your state wage laws. You need to make sure that you check on those. Now, sometimes I'll put those penalties in, even if I know they may violate the wage laws, but then I always tell the client to, because you want to scare the physician into making sure that they comply, right? But I always tell the client to make sure that you check the applicable laws before it comes time to actually enforcing those provisions. As an alternative to imposing penalties, you may include incentives that if they complete their records within a certain period of time, or have a certain, minimal variance, then you will give them an additional incentive. So you're not penalizing them, you're just giving them additional money if they complete their records timely. If nothing else, you may want to clarify or reaffirm that they can be liable for damages that you suffer because of their breach of their agreement to timely complete the records, including any lost income you may have because you can't bill for the services because they weren't timely, the records weren't timely completed. You may want to require them to use approved record systems. Almost everybody's on EHR, but that was a big deal a few years ago when physicians were refusing to go on the approved AHR system, but you still may want to make sure that that's in the agreement. Confirm that you own the records, that the records for medical services that are being provided, that they are owned by the group or the facility, not by the individual provider. That you want to avoid that dispute down the road. Make sure they return the records if the agreement is terminated, and you may want to address post-termination access to records. When doing that, just remember that HIPAA is out there, and they're not entitled to access records for all purposes. For example, you can only provide records to another provider for certain healthcare operations, not all their healthcare operations, but only certain healthcare operations. Just make sure that you, if you're going to give them access, that access complies with the applicable laws. Make sure that your contract either incorporates those laws or refers or is subject to the applicable laws. Most contracts, for physicians especially, will have a general clause that says that nothing in the contract is intended to interfere with the exercise of professional judgment. That's just one of those things that is carried on forever and ever. It was more important in the days of corporate practice of medicine, and still is important in your states if you have a corporate practice of medicine doctrine, because that helped ensure that your contract or your relationship did not violate the corporate practice of medicine if that physician or provider was able to maintain their exercise of independent judgment. Still probably a good idea to put it in there, but just make sure that it is not unfettered. Make sure that they still have to comply with the other contract terms. You may want to reserve certain rights to yourself, including the right to accept or reject patients, or the amount of the charges that you're going to charge for those providers' services. Qualifications, right up there with performance standards, qualifications is a key provision to have in all of your contracts, and it is often overlooked. The key here is you want to make sure that you condition that contract on their satisfaction of those qualifications. So if before or at any time during the contract they fail to satisfy those qualifications, that gives you a basis, that is a condition for the contract, and it allows you to terminate the contract. Some of those qualifications are that they have to successfully pass any pre-employment screening that you might have, whether it's background checks, medical tests, things like that. Certainly they have to be licensed in your particular jurisdiction. I would put in their license without any kind of restriction. They need a DEA registration and State Board of Pharmacy authorization without restriction. They have to have appropriate medical staff membership and privileges without restriction. Make sure that in your agreement, particularly if you're a hospital or another facility that has a medical staff, that you don't guarantee or unwittingly warrant that they're going to have those medical staff privileges. Instead, make it clear that their medical staff membership and privileges is still determined by your normal credentialing process, and there's nothing in the contract that guarantees their medical staff membership or privileges. You may consider ensuring that they are board certified or at least board eligible if that's important to you. You want to make sure that they maintain their insurability under your malpractice policy at standard rates. You don't want a situation where they suddenly become uninsurable or you have to pay a gazillion dollars in order to continue their insurance. You want to provide that as a basis of their qualifications so that you can terminate if you can't get insurance at a fair price for them. Make sure that you reaffirm their clinical competence, that they have to at all times maintain their clinical competence and the ability to perform the services. Not only their clinical competence, but they have to have the physical, mental, and emotional ability to perform the services. Make sure that they, as a qualification, that they participate in payer programs that you identify. Specifically, they can't be excluded from federal or state Medicare programs, including Medicare and Medicaid. You cannot contract with excluded providers. That's the long and the short of it. If you're going to participate in Medicare or Medicaid, you can't contract with excluded providers or anybody else, really. That's a violation of the civil monetary penalties law. If you do, then you may have a big repayment back to the government on those situations. So make sure that you've got a provision that if they are ever excluded, that you can terminate the agreement. Make sure that the contract states that they're eligible to provide services under other relevant contracts. So, for example, you hire this particular physician, you're a radiology group, you hire this physician to provide services to a particular hospital. Make sure that as one of their qualifications that they have to satisfy the qualifications under that other agreement. So if the other hospital comes in, the client hospital comes in and says, we don't want this doctor providing services, we want you to terminate them, that it allows you to terminate them and that there's that they failed to satisfy the relevant qualifications. You might want to consider if there are other qualifications you might want to impose there. Along with those qualifications, you ought to include certain representations and warranties in your agreement. First and foremost, make sure that they represent and warrant that they satisfy all of the qualifications, those qualifications we just talked about. Make sure that they represent that they are not subject to any contractual or other limits that would adversely affect their ability to perform the services. They're not subject to any kind of a non-compete or some other contract that's going to interfere with their services. Make sure that they represent and warrant that they have truthfully responded to your questions or credentialing, so if you find out later that they lied about it, that you can terminate their agreement. In addition to, or as an alternative to that type of statement, a lot of contracts will go through and simply affirm that they've usually it's limited to the last 5 years, that they've got to represent and warrant that they have disclosed all of the following that have occurred in the last 5 years, and then there's a long laundry list of things like investigations, malpractice claims, licensure actions, those types of things. And finally, make sure that your representations and warranties require them to provide you immediate notice if they fail to satisfy the qualifications, they become aware of any facts or notice of potential claims, discipline, adverse action, investigations, anything that may subject you or them to liability, or they fail to satisfy any of the representations and warranties. Next, exclusivity. If your contract is not exclusive, meaning this is not the only provider you're going to deal with to provide these services, then make sure you specify it in there in the agreement and make sure that they will cooperate with others providing those services. On the other hand, if it is intended to be exclusive, maybe you're contracting with a particular radiology group or a particular radiologist or pathologist, those types of situations, and they have an exclusive agreement, be careful about those, okay? Those can really come back and haunt you. Make sure that you carefully define the scope of what is exclusive and what is not, because you may have other providers on staff with privileges to provide some kind of overlap. You may have, for example, some cardiologists who are providing certain types of radiology services. Make sure you're really careful in how you define that exclusivity. You might want to allow for appropriate exceptions to that exclusivity, including maybe grandfathering in existing physicians with privileges or something like that. You'll want to condition the contract and that particular physician's privileges on the continuance of the exclusive arrangement. So if, for example, you determine that you no longer want to have an exclusive arrangement with this particular group or this particular provider, and you terminate the agreement, that automatically terminates the privileges or medical staff membership to the extent that it would conflict with the contract you're going to enter into with somebody else. All right, that brings us to compensation. You wondered when we were going to get to that. That's the one the physicians are most concerned about. Let's talk about the compensation terms. Now, I spent a whole program going through physician compensation last summer, so I'm not going to spend all that time going through those terms. To the extent that you would like to participate or review those things, you can go to our website and you can call up that program, and I talk more about the different compensation methodologies and the like. The bottom line here is when you're dealing with compensation, you really got to be concerned about the federal regulations and, to the extent applicable, any state laws, particularly the Anti-Kickback Statute, Stark, and the Civil Monetary Penalties Law. In general, those require that any compensation structure you come up with for these providers has to be fair market value, not based on the volume of value of referrals or potentially other business generated between the parties, and it has to be commercially reasonable, meaning that the whole arrangement makes sense. If it's for contractors, independent contractors, you need to make sure that the compensation is set in advance and that you don't have a change within 1 year and that it's in writing. As far as the compensation structure, most of you are going to have some kind of a base salary, whether it's wages or per year or some other compensation. You just want to make sure that you specify that compensation structure, whether it's annual, whether it's hourly, whether it's per shift, fee schedules, like for every type of this service we'll pay you X dollars, those types of things. When you do that, though, make sure that you confirm what counts toward the compensable coverage. So, for example, sometimes you may be paying a physician X dollars per hour that they provide services, but is that all services? Is it just clinical services? Are you going to pay them that same rate? You're suddenly going to get a bill from that physician for several $1,000s because they attended meetings that they were otherwise obligated to attend under the medical staff bylaws, or they participated in these programs or those programs. Make sure it's clear which hours you're paying for and what's not covered. Now, if you're dealing with mid-levels who are paid on an hourly basis, they are likely not going to be exempt, and so you're limited in what if they're working on your behalf, then generally you have to pay them the hourly rate because that's what the wage and hour laws require. On the other hand, if you're working with physicians, physicians are generally exempt from the wage and hour laws, so you can specify that, look, we are going to pay you an hourly rate. We will give you $200 per hour, but it's $200 per hour that you're engaged in clinical services. The other things that they're doing, you know, the participation on committees or the participation, you know, that all medical staff members have to do just as a member of the medical staff, but we're not paying you for that. And the reason is because we factored that in when we were setting the compensation rate for your clinical services. The bottom line here is you may adjust that, whatever, just don't overlook and don't get caught up or caught by a situation where there's a dispute about, well, wait a minute, that's not what I thought we were paying you for. That goes back to that original statement I had. Make sure that your contract is not only clear to you, but it's clear to anybody else so that nobody can misunderstand what you're paying for or what you're not paying for. Your compensation structure should include the payment according that you'll make payment according to the payroll, the employer's normal payroll schedule or policies. If it's an employee, your state wage laws will normally require that you pay either monthly or bi-monthly. You can't just simply pay them on a quarterly basis if they're an employee for most situations. You'll usually want to include documentation requirements if they are getting paid based on per hour or per shift, that you make a provision in there so that they have to submit appropriate documentation. Make sure you don't forget about partial shifts. So if you're paying them on-call coverage and it's per shift, but they only work half a shift, then make sure that you prorate, the contract allows you to prorate those shifts accordingly. What about productivity bonuses? As an alternative to, or in addition to, kind of a base salary, it's very common now to have some kind of productivity component built into that. When you're talking about productivity or incentive compensation, remember that in order to satisfy Stark and the Anti-Kickback Statute, generally you pay based on personally performed services. The services they personally render, you generally cannot pay them based on their referrals for ancillary services or services that are provided incident to. There's a limited exception for that under the group practice safe harbor, but that's under a different safe harbor. You have to be careful about that. The bottom line is that, you know, the general rule is if you're paying productivity, you can only pay them based on the services they personally perform. Beware of situations where they may come up that you didn't think about it, but you're paying them based on referrals even though you didn't realize it. Things like if you're paying them based on a share of your overall profits. Outside of the group practice context, that generally doesn't work because the more referrals that they make, the more money they make if they're getting a share of the overall profits. If you're paying them based on ancillary services order or services performed by others, those can all be problematic and create Stark problems. If you are paying them a productivity component in addition to a base salary, make sure that you adjust or set that productivity level so that you're covering the services that were performed under the base salary. So, for example, maybe you're paying work based on work RVUs. Instead of them giving them the base salary plus X dollars per work RVU, you may want to give them a base salary and then plus X dollars per work RVU in excess of 500 work RVUs or 1,000 work RVUs or something like that, so that that bonus kicks in only after you've already paid them for the salary or they've covered the cost of their salary. As an alternative to paying on work RVUs, I'll talk about that in just a minute, you could pay them based on the net income, because if you're just paying them based on work RVU or billing, then that's really not how you get paid. You get paid based on what you collect. So you may want to turn it around and pay the physician or provider based on the amount that you're able to collect, not just on what you're able to bill. It's real common now to use work RVUs as kind of the standard for making payments. That's fine, but just remember that work RVUs, there are some risks associated with that. Again, one of them is if you're paying based on work RVUs, that generally means you're paying based on what you bill, not necessarily what you collect. Make sure you define your work RVUs to be the most recent applicable work RVUs. Include any appropriate adjustments to your work RVUs. So, for example, if they're assisting in surgery or combined procedures, the work RVUs values generally are reduced by those. Make sure your contract confirms that you can reduce the work RVUs, or maybe if there's contractual adjustments, that you can adjust their work RVUs accordingly, so it's not a situation where you can't collect for those work RVUs, but you're still paying the physician or provider in full. At least consider the potential ramifications. In addition to, or as an alternative to pure productivity, you may pay based on quality indicators, if they complete their records or they get certain patient satisfaction scores or things like that. If you're going to pay excess call, you may consider that. Bottom line here is there's lots of ways to structure your incentive-based compensation. Just make sure that it doesn't improperly induce or reward referrals. If you're going to pay a bonus or productivity-based compensation, consider capping the maximum compensation that you pay to make sure that you don't fall outside that fair market value range. You may tie that to MGMA statistics or otherwise. Make sure you clearly articulate the formula and the conditions, and I like to provide an example of how the formula works. The key here, again, is quite often when you're drafting those, when I look at ones that the clients have drafted, it's clear the client knew what they meant, but it's not clear to a third party what they meant. So you need to make sure that you clearly draft that formula, because if there's ever going to be a dispute, it's going to be around compensation issues. And if you're the one who drafted it, then the general rule is it works against you. So you need to make sure that it's very clear. You might have an objective third party come in there and try to interpret what you wrote to make sure that it really is clear to third parties on that. You should identify the schedule for payment. Are you going to pay this productivity bonus on a monthly basis, a quarterly basis, an annual basis? You can generally do that. If you are going to do that for the bonus portion of it, consider whether or not you're going to provide any kind of draw against that bonus, particularly if you're going to pay purely based on a productivity model. You're usually going to allow that physician to take a draw against that productivity bonus as they're going along. If you're going to allow them to take a draw against that productivity bonus, then you're usually going to want to cap that so that they can only get up to X% to ensure that they don't get too much down the road if their productivity drops. You will normally want to have some kind of periodic true-up. So maybe you look at this on a quarterly basis and you either pay any difference or you require repayment or do some kind of an offset on a regular true-up period. That can be quarterly, it could be annually. If you're going to pay a bonus or productivity, I usually put in there that they have to be employed by the end of the bonus period, so that if they terminate during the bonus period but before the end of the bonus period, they're not entitled to that bonus, that they have to be employed for the entire bonus period. That provides a bit of a golden handcuff and may avoid a situation where they claim that they were on track or that they provided the services, but they really, over the long haul, that they really didn't satisfy the requirements. You should specify whether any compensation is going to be paid following termination. General rule is, of course, you don't want to pay them after you terminate their agreement, but if you structured the arrangement such that they get a bonus or they're paid based on their collections, and those collections or bonus, or the bonus period runs after the contract terminates, then they may have a claim for that additional money. In fact, if you're paying them based on collections, then that could run out perpetually, and you might have to continue sending checks afterwards. You don't want to get in that situation, so you want to clarify in your agreement that once the contract's terminated, that their right to receive any additional compensation terminates. They have no expectation or accrued right to those benefits if they are not employed as of or once the contract terminates. Make sure you specify that. At the very least, if you're going to pay them based on collections, make sure that you have a time period set, that those collections will be determined, through 30 days after the contract is terminated, or 90 days or something like that. The better rule is just to structure it so you don't have these payouts after the contract's terminated. Make sure you include the documentation requirements that you need from the physician, whether that's monthly timesheets or some kind of services, particularly for medical directors and others. You want to be able to document that that physician provided the services for which they're getting paid in case you're ever audited. So you want to have some kind of documentation provisions in there. Make sure when you're looking at this whole formula that you're complying with applicable wage laws. If you violate wage laws because you didn't pay money that was due, that you promised, but the contract terminated and you just were refusing to make those payments, you could be hit up with some pretty severe penalties, including treble damages and attorney's fees. In addition to your compensation and productivity basis, there may be other compensation that you're providing. Maybe it's a signing bonus, a relocation assistance, student loan repayment, deferred compensation. By the way, anytime you get in a deferred compensation plan, make sure you check with your tax advisor because those raise a whole bunch of different issues. You may agree to pay for malpractice tail insurance from a prior employer, you know, whatever it is. There's lots of other compensation structures out there that you kind of provide in order to sweeten the pot and get the person to join. In doing that, just remember two things. First, make sure that when you judge the overall compensation for purposes of fair market value that you include this additional stuff. Second, remember the tax consequences of all of that, because the general rule is if you're paying into this compensation, including these things, it's going to be taxable, and you're going to have to issue a W-2. So you want to account for that in your agreement to make sure that those are all subject to applicable withholding. You might want to, for these additional add-on things, have a provision so that if the physician leaves within a certain period of time, that physician is obligated to make a repayment back to you. That repayment could be they have to repay the entire signing bonus or the entire relocation assistance, or maybe it's prorated over time so they only have to pay based on the length of time remaining in their original term of their agreement. Sometimes those are structured as forgivable loans, so we will provide this additional assistance in the form of a forgivable loan. Just remember that that forgivable loan is also taxable, that as you go along and you forgive that over time period, the amount of the loan forgiveness is going to be taxable to that particular provider. If you're going to set it up as a forgivable loan, you may want to have a promissory note along with appropriate security. Benefits. Make sure that you also address benefits. Benefits could be anything from health and dental insurance, life insurance, and so forth, all down the list. It used to be that I would set all those out. I've gone away from that now. Instead, my preferred method is simply to say that under the benefits section that physician or provider will be entitled to employee benefits policies consistent with our existing policies for similarly situated employees. And I leave it at that. The reason that I do that is because your employee benefits plans may change over time, and you want the flexibility to be able to change those. You don't want a situation where the benefits are going to be affected by your employee benefit plan. You also don't want a situation where your contracts are conflict with or are at odds with your employee benefit plan. So I've kind of adopted the method of simply referring to the employee benefit plan and incorporating your employee benefit plan to identify their benefits. You may still want to give a list, but if you're going to give a list, make sure that you have a big caveat on there that this is a summary only and the benefits are actually as set forth in your employee benefit plan. And most importantly, make sure that you reserve the right to change those plans at any time and to have those changes apply to that particular provider. If that physician is going to be part-time or PRN, make sure it's clear that whether they are or are not entitled to those benefits. You may want to specify that they're not entitled to the benefits. If you are paying the provider as an independent contractor, general rule is don't pay them any of these types of employee benefits. That is a huge red flag when it comes to classifying them as an employee or as an independent contractor. If you've got certain highly paid physicians or highly paid employers, and they're getting more than your other employees at your facility, their benefits are different, then that could subject you to penalties under some of the employee benefit tax requirements that apply to highly paid employees. Make sure that you check with your advisor on that. All right, taxes, an unfortunate reality for all of us. Just remember, if it's employment, you generally have to do the withholdings on that. And remember that it applies to, the taxes apply to, when you're talking about the taxes, that they apply to a lot of those additional benefits that you're providing to them, that those are taxable benefits. You may want to confirm whether the employee is exempt or non-exempt under the FLSA to determine whether or not they're going to be entitled to overtime and the like. Physicians are generally exempt. For mid-levels, if they're salaried, they're generally exempt. On the other hand, if the mid-level is hourly, then they're generally not exempt. Offsets. Most wage laws will prohibit you from offsetting amounts that the employee owes you. You can't offset those amounts against the compensation that you owe the employee unless you specify that in the agreement. So I like to put in a provision that where the physician or the provider expressly authorizes us to offset any amounts that we owe them against any amounts that they owe us. That could be any repayment obligation that they have, overpayments, penalties, damages. You just want to make sure that you check your wage and hour laws for employed providers to ensure that it's consistent with any requirements that you have in your particular state. Requiring referrals. A lot of people say and put in their contracts that we can't require referrals and nothing in the agreement will require referrals. Actually, under Stark does allow you to condition compensation on the provider's referrals in certain circumstances. Stark, under 42 CFR 411.354 subsection D4, states that you may condition compensation on referrals if you have a bona fide employment or personal services arrangement, that the compensation is set in advance for the term of the arrangement, and the referral requirement is set out in writing and signed by the parties. So you want to have this provision in your contract. The referral requirement cannot apply, it doesn't apply, if the patient prefers another provider, the insurer determines the provider, or the physician believes the referral is not in the patient's best medical interest. So they've always got an out. In addition, you can't require referrals, or you can only require referrals that relate solely to those physician services covered by the scope of the employment or personal services arrangement. So if this is a part-time physician, you can require referrals for the services that they perform while he's acting under that part-time agreement on your behalf, but you can't also require him to send over patients when he's conducting his separate practice outside of the scope of your agreement. And finally, that referral requirement must be reasonably necessary to effectuate the legitimate business purposes of the compensation arrangement. Bottom line here is, if you're contracting with physicians, you probably want to put this provision in there, particularly when you want them to require them to use your own facility for ancillary tests, make referrals internally, those types of things. You're going to want to have that in there. For mid-levels or under the anti-kickback statute, they don't have a similar provision like this. I don't think that there's a whole lot of risk if you include that in there. I doubt that the OIG would ever come back against you for an anti-kickback violation, even though there isn't a similar provision in the anti-kickback statute. So I think the risk is minimal, and I would encourage you to consider putting such a provision in there. Some people will disagree, but I've never seen the OIG go after anybody for such a provision. Billing for services. Your contract should address situations and confirm that the practitioner assigns the right to bill to the employer, so that the employer has the right to bill for all of the services that are provided by that particular provider. Medicare has limits on the ability of that provider to reassign the right to bill, but it always allows them to reassign it to the employer. It generally allows them to reassign to the independent contractor. There's certain limitations that apply there, but I've never seen the government go after or strictly enforce those limitations. The contract should appoint the employer as the agent to handle the fees and billing, confirm the employer has the right to set the fees, require the physician to cooperate in the billing, including make sure that they comply with payer requirements, that they timely, accurately, and appropriately document the services rendered, and that they use proper CPT or other billing codes. Term and termination. All right, this is a hugely important provision in your contracts. It's basically your escape hatch. You can deal with a lot of problems in your contract as long as you can get out of it relatively easily. As far as the term of your agreement, make sure your agreement sets the term. It could be for 1 year, it could be for 6 months. Theoretically, even if you don't have a term in there, if the parties continue to perform, it still continues to on the same terms, so it's not that critical. Alternatively, you may have an auto-renewal provision where the contract is for 1 year, but it will automatically renew unless one party gives prior notice to the other party or terminates the agreement. That's fine too. That used to be more important when it would be a Stark violation if the contract terminated. In the wake of the recent changes, If you continue, if you have a holdover contract, even though the express term expired, if the parties continue to perform, then that is not a Stark violation, so it's not as important. Alternatively, you may simply have a contract term that says, hey, it begins on the commencement date and continues until terminated under the agreement. Of course, the net effect of that is the same as the auto-renewal provision, or conversely, the auto-renewal provision is the same as, hey, the contract begins on the commencement date and continues until either party terminates, either way. Sometimes they like to put in a termination provision just to make the physician either feel more comfortable or to create this expectation that the physician is going to remain for a certain period of time. Termination provision, extremely important. You almost always want to have some kind of a termination without cause upon notice that allows you to get out for any reason or no reason at all, as long as it's not a bad reason or an illegal reason. My norm is 90 days. Sometimes you'll have 180 days. Sometimes you'll have 30 days. Just remember that that cuts both ways. You may want to require the physician to stay there for a long time. On the other hand, if it's a bad physician, you may want to cut them loose earlier. So again, my norm is 90 days. If you are going to have that provision in there, you may want to add a provision that allows you to immediately terminate the physician or suspend them from their duties so long as you continue to pay them during that 90-day period. That way, if they're a bad actor, they're poisoning your well, you don't want to terminate for cause, but neither do you want them around there any longer, then you can cut them off, you can go ahead and terminate them, and then you pay as damages or it's not actually damages, but you pay under the contract the compensation they would have otherwise been due under the unexpired portion of that 90-day termination provision. If you're going to do that, make sure that you define what that compensation is during the period. If it's productivity-based, for example, there may not be a set compensation rate. So you may have to go back in and look, okay, we're going to define that compensation as the compensation that physician received during the 90 days immediately prior to the termination notice or some other methodology. Conversely, you may want to put in a provision that if the physician terminates without giving the 90 days notice, that there is some kind of a penalty that they must face so that you don't have to come in there and prove damages. Maybe they have to pay for locum tenens, maybe there's a liquidated damages provision, or something like that. You may want to set that out in the agreement. Regardless, you're going to want to make sure that it's clear that that physician still has to comply with the contract terms during that 90-day period. If they fail to do so, that you can go ahead and terminate them for cause under other provisions of the agreement. That brings us to termination for cause. Usually you'll have two termination for cause provisions. One is termination for cause for generic material breaches. Usually you have to give 30 days notice of an opportunity to cure. If they fail to cure within that 30-day period to your satisfaction, then you could go ahead and terminate at the end of that period. You may want to specify what cause for termination is under those circumstances. Usually it includes a material breach of the agreement, including but not limited to. Make sure you don't limit yourself. It could be a change of circumstances. If, for example, there is a change in a regulation or something like that that affects the compensation, you may want to include that in there. It could be regulatory noncompliance or potential liability or any others you may want to specify. Just like with the 90-day provision, you may want to leave yourself the out to terminate or suspend immediately, even during that notice period, so long as you compensate them during the remaining unexpired portion of that 90-day period. Finally, you need to make sure that you've got a provision that allows you to terminate immediately for certain specified conduct, including failure to satisfy the qualifications or representations and warranties. If they're no longer qualified, you need to be able to terminate immediately. Also, termination for death or disability, a disability that prohibits the provider from performing the substantial material duties. Make sure that that's subject to the ADA. Repeated violations of performance standards or repeated breaches. You don't want a situation where you've got a physician who continually he violates the performance standard, but you give him the 30-day notice, he comes in and corrects it for that 30 days, but then violates it the next month. So you may want to have a provision that allows you to terminate immediately for these serratum situations so long as you gave prior notice on a prior occasion. Allow for termination if the provider commits, is charged with, pleads no contest to, or is otherwise convicted of a crime. It's common to have a provision in there that you can terminate if the provider commits, if they are convicted of a crime. But the problem is, what if they committed it, and you want to be able to terminate them immediately. Or even if they're charged with a crime, you usually want to have a provision in there, or I would encourage you to have a provision in there, because if they're charged with a crime, there's this bad aura on your organization. It may adversely affect their ability. Granted, they're supposed to be innocent until proven guilty, but hey, your contract, you can have in there that if they're charged with a crime, you can terminate immediately. I think that's just a lot safer and allows you to avoid situations where you've got this person who's a suspect in a serious criminal case and you've got to keep them on staff. Allow termination for conduct that is unethical, dishonest, that jeopardizes patient safety or the employer, or impairs the reputation of the employer, or exposes the employer to liability. Abuse of drugs or alcohol that poses a risk to patients or the employer. You may want to include a provision in there that requires them to comply with your employee drug testing policy. Performance may have a provision in there that allows you to terminate them if their performance may subject the employer to adverse action by an agency, or have a catch-all, any other conduct that justifies immediate termination per the employer policies, or whatever else you want to say in there. Again, those immediate termination provisions are very important. A lot of times you'll have a mutual termination provision in there that says the parties can terminate by mutual agreement. That's really worthless, because the parties can always agree to terminate by mutual agreement. If they both agree, then it doesn't matter whether you've got it in there or not. So it's really just takes up space in your agreement. In your agreement, you want to cover certain post-termination obligations. Quite often this isn't in there, but you should consider making sure that it's in there. Again, address the right to receive compensation post-termination, especially if there's like a bonus period. Make sure you've addressed whether or not they're entitled to that bonus or money that comes in after the termination period. Make sure they have an obligation to return all property, keys, documents, etc. This is a huge one. Make sure that they complete their records before the termination or within X days after the termination, maybe 24 hours or 3 business days after the termination. You don't want a situation where you terminate this person and they've got, 100 or 200 charts that are out there that haven't been completed, and suddenly you're SOL because you can't convince them to come in there and complete the records. You want a provision in there that requires them to do it. You might actually set forth the penalties or damages that are associated with their failure to do it. If they fail to do that, you can always sue them for breach of contract and include the damages, but by specifying it in the agreement, chances are you're going to have better luck getting them to complete their records prior to, or before or immediately after termination. You might want to address that if you are going to terminate them, that you come up with a mutually agreeable notice that can go to patients, that maybe gives the patient the right to select who their provider is going to be in the future. You're not required to do that, but that's a relatively common provision to have in there. You should require them to cooperate in transferring their care or their duties to others, and cooperating in responding to investigations or claims that arise out of their agreement down the road. You should have a provision that addresses the effect of termination on their privileges. Generally, I like to have a provision that once their contract terminates, that it allows us to, it constitutes a resignation of their associated privileges at the hospital or facility. That way, if you've got a situation, you terminate a physician because they're a bad physician, they've got problems, you don't have to go through continue to allow them to practice at the hospital because they've got privileges, or you don't have to go through the fair hearing process if you want to terminate their privileges at the hospital. It allows you to terminate their privileges with the contract. Now, the benefit is that's more efficient, it saves you time and money and headache. The downside is if you're going to terminate it without giving them the due process under the Healthcare Quality Improvement Act, you're not going to get the immunity under the Healthcare Quality Improvement Act. But you can always decide not to terminate their privileges immediately if you don't want to. You could follow through with the fair hearing under the bylaws. So it just gives you more flexibility by having that provision in there. If the physician balks, at the very least you could have a provision in there that you can terminate, their privileges terminate automatically unless their privileges are the termination is reportable to the National Practitioners Database, in which case they would be entitled to the fair hearing process under the bylaws. Liability insurance, make sure that you address that in there. Generally, if they're an employee, you're going to be providing the liability insurance. If they are an independent contractor, you will want to require the contractor to provide the insurance. If you're the employer, make sure that you undertake to provide the insurance during the term of the agreement so that you're not necessarily on the hook for tail insurance unless you affirmatively agree to it. Make sure that you retain the right to select the insurer, that you specify the minimum policy limits, especially if you're requiring the independent contractor to maintain that. That's usually $1 million, $3 million, could be up to $5 million for certain specialties. Make sure that you reserve the right to have that contract subject to reasonable terms, limits, and exclusions. So the policy is subject to those reasonable terms, limits, and exclusions, so you're not guaranteeing insurance coverage, only that you're going to purchase a policy that may otherwise be subject to terms, limits, and exclusions. You may want to reaffirm that that policy you provide is not going to cover the physician for services they perform outside the scope of the agreement. And if they are going to provide services outside the scope of your agreement, they're going to moonlight, that they have an obligation to ensure that they secure alternative insurance coverage so they don't come back, you're not sued for what they do outside the agreement. If they're going to be using their own car in providing services, you may want to make sure that they cover automobile liability insurance with certain limits. You may want to consider errors and omissions liability insurance in certain circumstances. Regardless of the form of insurance, if you're picking up the cost of it, you may want to preserve your right to terminate the agreement or your obligation to provide insurance if the premiums exceed those charged to similarly situated specialists in the service area. So suddenly you don't have to pay exorbitant rates because you've got a physician with a bad claims history. What about tail insurance? Well, you can decide whether or not you want to purchase that tail insurance or require the provider to purchase the tail insurance. That is a common situation that's subject to negotiation. So you're going to probably want to specify that in the agreement, or at least don't bind yourself to it in the agreement if you don't need to. If you're going to address it, you're going to usually want to address who's responsible and the conditions for purchasing the tail insurance, whether it's the employer's responsibility, whether it's the provider's, or maybe both. Maybe if it's a situation that if the provider terminates without cause within a certain period of time, then they're going to have to purchase it. On the other hand, if the employer terminates without cause, then the employer is going to terminate the insurance. You may want to specify, especially if you're purchasing the insurance, the duration of it. Is it going to be perpetual, or is it sufficient to purchase a tail insurance policy that covers the relevant statute of limitations period? Make sure that the terms for that tail insurance are similar to the underlying malpractice insurance coverage with the same limits and the same general coverage, and reserve the right to purchase and offset the cost against the amount owed to the provider. So if the provider is obligated to purchase the insurance and they fail to do so, then have a provision in there that allows you to purchase it on their behalf and then recover the amounts of that from any amounts you may owe the physician to the extent it's consistent with wage laws, or allow yourself to sue the physician if they fail to purchase that insurance. Indemnification. These have started popping up in some of the agreements. These are situations where the employee does something wrong and you want the employee to indemnify you. Now, those usually don't sit very well with the employees, and quite often you're not going to go and enforce that against the employee, particularly if it's an employee you want to continue on with you for any period of time. So use indemnification provisions sparingly. Consider it before you actually put it in there, because a lot of times the provider won't sign indemnification agreements. Sometimes you don't need them, because if the employee has violated a term of the contract or otherwise committed a tort, then you can generally sue them for contribution or sue them for breach of contract and recover the same amount of damage as you could get under an indemnification provision anyway. But having the indemnification provision in there does help should you need to pursue them. If you are going to put it in there, just assume that the employer is going to, or the employee is going to want a mutual indemnification. So if they have to indemnify you, then also you have to indemnify them for any conduct you engage in. So you may want to consider, well, who's most likely to have the indemnification obligation in those situations. That may affect whether or not you want an indemnification provision in there. That indemnification normally applies to things like breaches of the agreement, violations of law, regulation, or policies, or an intentional, grossly negligent. Less common to have negligence acts and omissions, but you could put it in there. But for things like malpractice, billing errors, and misrepresentations and the like. If you are going to put the indemnification provision in there, consider its effect on existing insurance. a lot of your insurance policies will have provisions that do not cover you for contract liability. And if you've got an indemnification provision, that insurance may not cover, or you may void coverage for what might otherwise be covered. Or you may set up the indemnification provision so they're only required to indemnify you to the extent that it's not otherwise covered by applicable insurance. The bottom line is make sure you coordinate the indemnification provision with your insurance policies. You'll want a confidentiality provision in your agreement. It should apply to patient information, personnel information, and other things that are up there. That is important not only for HIPAA purposes, but also it's important because if that physician leaves and decides to compete with you, this confidentiality provision is helpful in trying to rein them in. You may want to actually include damages or remedies in your agreement for breach of the confidentiality policy, so you don't have to prove actual damages. You might have a liquidated damages provision in there, or allow for you to come up with and seek an injunction but not have to pay fees or bond for that. HIPAA compliance. A lot of you will include provisions in there for requiring the employee to comply with HIPAA. It's really unnecessary because you already have an agreement in there, presumably, that requires them to comply with applicable law, and they have to comply with the law anyway if they're a provider. So you can put it in there, but it's not essential, not really required. You might have to consider having a business associate agreement in place in certain circumstances. That's generally not going to apply to your clinicians for any number of purposes, or for any number of reasons, but it may apply if that employer contractor is providing administrative or other services on your behalf that's outside treatment purposes. Even then, it usually doesn't apply if they're a medical staff member because they're an organized healthcare arrangement. The bottom line is you may want to consider the HIPAA stuff, but the general rule is you don't have to have a specific HIPAA obligation in your employment or contractor arrangement with certain exceptions. Outside activities, you should specify in your agreements to the if and to what extent you're going to allow the physician or provider to moonlight, to provide services outside your agreement. Now, for contractors, you're probably going to allow them to do that. If you don't, then that would be an indicia that they are really employees. For employees, you're going to want to have some provision like this in your agreement. Usually it's going to say that they can't engage in any professional services without your consent, and that you reserve your right to revoke that consent at any particular moment in time. You may want to specify that who owns the fees that are generated outside the scope of the agreement. That usually belongs to the provider. You may want to specify that they're obligated to secure insurance coverage. You'll want to coordinate with your non-compete. We'll talk about that in just a minute. You will certainly want to have a catch-all provision that even where you agree or specify certain types of services that they can perform, have a provision that they can't engage in any activity that would interfere with the performance of their services under the agreement, or that would compete with your services or increase any liability to you. That brings us to the non-competes. Bottom line here is check your state law, because states different on the scope of non-competes. As a general matter, non-competes for healthcare providers are generally enforceable. Some states don't allow that, but most states do. You just want to make sure you structure that non-compete to comply with applicable state law. In general, it has to be reasonable in time, the services to which it applies, and the geographic scope. So the time is usually going to be during the agreement plus X years or X months after the agreement. Usually you're safe if it's 18 months to 2 years. Getting beyond that for an employment agreement might be a little bit iffy, but it's really not a facts and circumstances test in most cases. Same thing with prohibited services. It usually needs to apply to the services that the physician performed on your behalf, not completely extraneous services. Geographic scope, that should generally be limited to your geographic service area where there would really be competition to you. It may be broader. Be careful about going too far. Even if there is a non-compete in there, it's construed as overly broad, you'll want to include a provision in there that allows or authorizes the court to do what's called blue penciling, where they can restrict the scope of it so it's still enforceable rather than just junking the whole non-compete. Like a non-compete, you'll probably want to have a non-solicitation provision that prevents them from going out and hiring away your employees or taking away your patients. Again, make sure you check your state law and make sure that that restriction is reasonable in time, scope, and geography. For your restrictive covenants, to the extent consistent with state law, you may want to include certain remedies, certainly an injunction that allows you to get an order prohibiting them from competing. If you're going to have an injunction, make sure that it allows you to get it without the necessity of posting a bond, because posting a bond can be cost prohibitive. You want to allow yourself to recover attorney's fees if there's a dispute. You may want to specify damages or include liquidated damages, so you don't have to prove actual damages if they breach the non-compete. So instead, you agree in advance that if they breach the non-compete, they've got to pay you X dollars. Be careful that liquidated damages provision generally can't be a penalty. It has to bear a reasonable relation to your actual damages. My rule of thumb is generally maybe 6 months of what the salary was or the compensation that was otherwise due, but it really depends upon the circumstances. Intellectual property, this is an important provision also that's often overlooked. Generally, you as the employer, you're going to want to confirm that you own any intellectual property that that employee or contractor develops while performing services within this course and scope of their services for you, or while using your personnel, property, or resources. If you're paying them to provide the service, you should own whatever it is that they get paid to provide. On the other hand, the physician may push back, and it may be necessary just to reaffirm that to the extent they develop it outside the course and scope of their duties or without using your stuff, that they own that information. You may also want to confirm that the provider authorizes you to use their image or professional information for your healthcare operations, so you can use it for marketing or put on your website and the like. Employer resources. Quite often you'll have a provision in your agreement that says, and the employer will provide, necessary staff, space, equipment, the like. I don't like those provisions. I typically take all of those out. I don't think they do any good because it's assumed if you're employing or contracting with this individual that you're going to provide those services. The potential exception is for independent contractors. You may need to specify that to determine who's providing the equipment and the like. But generally, I take those out. They don't do any good. The providers, I've never seen them push back on that. They just assume that you're going to provide that. The problem with having it in there is if you want to go after them for breach of contract, they may turn around and say, well, you breached the contract because you didn't provide what you said you were going to provide. You didn't provide adequate support or adequate space or training. I think it just creates a potential for problems, so I generally advise against including those provisions in there. Your contract will normally have a notice provision that if you're going to give notice of termination or the like, that they will specify how that notice has to be given, whether it's by registered mail or whatever. Just remember that if that notice provision in there, you better darn well comply with it, or that notice is going to be ineffective. To make it easier to give the notice, I broaden that so to also allow notice by in person or by fax or by email with confirmation of receipt. You may want to consider something like that. You may want to consider an alternative dispute resolution. So if a dispute does arise, you don't automatically run off to court. Instead, maybe you go through some kind of a process, maybe requiring first good faith negotiations. And if that doesn't work, then mediation, and address a process for selecting the mediator and who bears the cost. If that doesn't work, then go to arbitration, and you want to specify the rules for the arbitration. Who is appointed as the arbitrator? If you can't agree, do you go with a panel of 3? What rules apply? Who bears the cost of the arbitration? Ensure that the arbitrator is authorized to award attorney's fees and damages as the result of the arbitration. You'll just want to address those in your agreement. Consider governing law. Generally, as the employer, you want to make sure that the law of your home state applies, and the venue of the lawsuit, if the lawsuit's ever brought, that it has to be brought in your county where you reside. That minimizes the exposure to you and the risk to you, and usually you'll have home court advantage in that situation. You'll generally want to prevent the employee from assigning their rights to subcontract it out to somebody else, confirm that it's personal to them. For even subcontractor or even independent contractors, that you expect them to provide the service. So prohibit any kind of assignment or subcontracting out, unless of course you want to allow that. Conversely, you want to reserve the right to assign that contract to your successor, or if there's a corporate reorganization or somebody else buys the hospital or your facility, you want to be able to assign that contract. Amendments, you'll it's common to put a provision in there that amendments have to be in writing, but usually that's unenforceable because the parties can generally orally agree to amend even that provision. Integration clauses. This is an important provision. It's a common provision to have in your agreement so that it says at the very end that there are no side agreements, that this agreement as set forth in the contract constitutes the entire agreement between the parties for the purposes of their subject matter. That excludes side agreements. Be careful with that. If you're going to put that in there, just realize there are no side agreements, or the side agreements are superseded by this agreement. Now, that generally favors the employer, but if you have a situation where this contract is replacing a prior contract, then this term could negate that prior contract. If there are obligations still owing under that prior contract, maybe a repayment obligation or some other obligation, and you want that to continue, well, you want to make sure that you account for that in those integration clauses. To that end, make sure that you coordinate this agreement with any other agreements that are out there, whether it's a prior agreement or maybe you have a contract to provide services to a third party. Your contract with this employee or this contractor is going to help you to comply with that, so you want to make sure that you have structured this agreement to be consistent with that other agreement. Just consider this agreement's relationship to those other contracts. Similarly, consider this relationship to your bylaws, particularly your medical staff bylaws. If there's a conflict, for example, between the process that's given under this contract and the bylaws, which apply? Usually I put in that the contract controls any contrary or conflicting provisions in the medical staff bylaws. Construction, have a provision in there that confirms that both parties have been involved in the negotiation and have had the opportunity to review it, so the contract is not construed more favorably against one party than the other. There are other provisions you normally want to put in there or often in there. No third-party rights, so no third party has the right to sue you for a breach of the contract. It's only the party to the contract. Severability, meaning that if part of the contract is held to be invalid, the rest of the contract still survives. Survival of specified provisions, that they continue after the termination of the agreement, particularly repayment obligations, non-competes, those types of things, you may want to specify those. Waiver of provisions in writing, that if you're going to waive any rights, that it has to be in writing and it doesn't extend to future waivers. Counterparts, confirm the authority of the persons executing the agreement, that they have the authority. All right, real quickly, I have kind of lumped all the independent contractor and employment arrangements in the same agreements. Just remember that if you're going to contract with an independent contractor, you have to go back and look at the right of control. Have you put so much in the contract that this person really is being treated as an employee? If you are, then that could create potential liability to the IRS or to third parties. So make sure that you specify or revise accordingly for independent contractors. If you are paid on a cost basis, the government requires you to put an additional access to records clause in there. So if you're a critical access hospital or other hospital that's paid on a cost report basis, then you need to have this particular provision in your agreement. That is it. I apologize. We went an hour and 32 minutes today. I think that that's a little bit over what the hour and a half I'd scheduled, but hopefully this has been helpful. If you have any questions, by all means, shoot me an email or use that chat feature. We hope that this has been helpful, and we look forward to the future webinars. Good luck.